Welcome to Channel 17, the Town of Colonie Government Channel.
Hi, I'm Colony Town Judge Peter Crummey, and welcome to Benchmark. We'll be discussing a variety of topics which intersect our town residents, together with the court system and the legal system. The Colony Town Justice Court is one of the busiest justice courts in the state of New York, handling over 24,000 cases a year. Colony Justice Court is involved with handling criminal cases, vehicle and traffic cases, and a variety of civil cases, including small claims cases and landlord-tenant matters. Today, we're very fortunate to have as our guest the Clerk of the Court, Julie Gansle, who will share with us information concerning landlord-tenant matters in the Town of Colony Justice Court. And hello, Julie, how are you?
Hi, good, thank you.
And thank you for joining us today.
It's my pleasure.
In connection with this matter. And as we had noted, the Colony Justice Court has a variety of cases that it handles over the course of a year, and you, being the chief clerk of the court, no doubt interact with so many of the citizens that come to your office asking for information concerning certain types of civil cases, including landlord-tenant matters. And as we get into that, I was wondering if you could share with us some of your own background in connection to serving as our chief clerk here in the town of Colonnade.
Absolutely. I was fortunate enough back in 1995 when I was a student at Russell Sage College to come to work for the town on a part-time basis. From there, once I graduated, I came in as a full-time clerk within the office, and in 2002 I was gracious enough to accept the position of clerk of the court.
Well, Julie, tell me this too, and you attended South Colony High School, is that correct?
I did.
And then from there, where did you go to school?
I started in Hudson Valley Community College, where I wasn't quite sure what path I was going to take, and out of a few courses I realized that my interest lied in criminal justice. So after I received my associate's degree, I from there went to Russell Sage College, where I obtained my bachelor's, and from there decided to go on to law school. So while continuing my full-time employment, I was able to commute to Western New England School of Law after a full day of work, and was able to, after 4 years, obtain my Juris Doctorate.
And you and your young family live here in Colony as well, is that right?
That's correct, yep. I'm married with 2 children, and we live in the town, and actually both work for the town, and I think it's a wonderful place to live and work.
Well, we know at the court that we're very fortunate to have you at the helm, and today we want to spend some time about landlord-tenant matters. As we all know, Colony has approximately 80,000 people residing in this town, and many of our residents reside in rental properties, not only in apartment complexes, but also renting single-family homes. And of course, we also have a variety of commercial properties which have rentals as well, which gives rise to a variety of cases that can be brought to the court. About approximately how many civil cases do we entertain a year, Julie?
Actually, we have a growing number. I think with the boom in the housing market, and as you stated, the rental properties, we see on average about 600 civil cases a year.
And when do we usually schedule those for action by the court?
Thursdays is our calendar day for civil cases. So every Thursday we have as many as are filed with us. So.
Now, how do people get started in commencing a landlord-tenant matter here in the courthouse? You probably have some people coming to your office saying, what do I do, and what can you tell them?
Actually, on a daily basis, we have quite a number of individuals. And I think the first question is whether or not we can assist them with that. And we are obligated to direct them as to the procedure of how to follow them, but we can't entertain advice and really walk them through it other than procedural aspects. Depending on whether the individual has requested or obtained counsel to assist them in the process, right off the bat would eliminate a few questions there. But should they proceed on their own, we explain to them the proper forms that are needed, obtaining them from a legal supply store, and there's various stores that they can obtain them through. But in general, there are 4 forms that we tell them to get in advance of their court date, 3 of which have to be filed in a timely manner and served in a timely manner. Again, all of those, being very specific as to procedures and laws with specific dates and different requirements to them. So we do explain all that to the best of our ability, letting them know the time restraints and the filing and the service requirements before the case is actually heard.
And landlord-tenant law can be, like every other law, very involved, and oftentimes when I see cases in the courtroom, many cases are presented by counsel, and certainly that can help ensure that certainly the procedures were followed. Sometimes we might find that as people get into the courthouse, as they proceeded on their own without the benefit of counsel, they may fall into certain pitfalls which may prevent them from getting the relief they were hoping to get because they did not follow the steps that are set out by New York State law. Where would people usually go? What bodies of law would they go to see and research the applicable law and for landlord-tenant matters generally?
The real properties law is the main source, and the RPAPL.
Okay, which is the Real Property Actions and Proceedings law, and the state legislature has spoken as to how these proceedings should be brought, and they can be very technical.
That's correct.
And in that way. When people come and want to file a form to start an action, that's called a petition, is that correct?
That's correct.
Okay, do they have to pay a fee to file that petition?
Well, they obtain the petition and notice a petition on their own and fill them out. The only fees incurred up until the filing would be the requirement of the signature of either myself or an attorney if they're working on behalf of the landlord. There is a $20 fee associated with that signature should they choose to have it signed by the clerk of the court. Once all the paperwork's filled out and actually served upon the tenant, then there's a $20 filing fee associated.
Okay. And also, too, in the process, I would imagine that a petitioner who is seeking relief through the landlord-tenant law has to also serve copies of the documents on the other litigant, which may be a tenant, it may be a landlord, and also prove to the court that service was made. So,
Right.
is that true? Okay.
Yeah, and there's different ways of service, and again, they should reference the real properties law to find out what is acceptable service, depending on whether or not they're seeking a money judgment or merely just to get the tenants out of the property. And the notice of petition, again, just tells the tenant where and when they need to appear for court.
Of the number of cases that are submitted under this civil jurisdiction in the town of Colony Justice Court, is there a trend as to what typically is the relief sought by a petitioner filing papers in a landlord-tenant matter? What are they looking for usually?
Most common, it's for non-payment of rent. So they're seeking to get the tenant both out and to recoup the past rent.
Yeah. Well, and it happens routinely. Is this type of calendar maintained every Thursday here in the Colony Justice Court?
Every Thursday, yes. The volume differs depending on what other caseloads are, but typically there are generally a handful every Thursday.
And I've noted in presiding over these Thursday morning sessions that there are some Thursdays wherein a large apartment complex, for instance, will bring as many as 25 actions for eviction based on routinely non-payment of rent. And that certainly can add to the court's agenda. When typically do those have to be filed with the court? If we hold court on Thursday, do those documents have to be in the court by Monday or before that?
They have to be filed with the court no later than noon on Monday.
Okay.
To be heard that Thursday.
Okay. All right. So, and it's hard for the court too, because you don't know on any given Monday what will be brought in by Monday noon.
That's correct.
And it can have an impact, and a direct impact on the court session for Thursday. There can be 5 or 6, or there can be 30.
As you know.
And that can be very involved for all parties. Do you find that sometimes some of the litigants don't appear?
Oh, yes. Yep. Whether it's an issue of service or whether they just choose not to appear, that is common. Sometimes maybe they've already evicted the premises and left and moved on. Whatever the case may be, yes, that does happen.
And as a result, of course, it's important that people always appear in connection with any litigation that they've been served papers on, unless they had some prearrangement with the other side. Oftentimes a non-appearance can result in a default judgment or some other type of relief being provided to the petitioner, which can include automatic and immediate eviction.
Correct.
And also can also include a judgment amount where a sum certain has been awarded by the court as against the defaulting party. What happens in a case when a court does award a money judgment, say for back rent, as against a tenant, and what can the landlord do to attempt to turn that judgment into money?
Well, once the judgment is decided from the bench, it's up to the landlord to submit a judgment to be signed by the judge. And they are entitled at that point to recovery. Should they not receive that, there's a little bit more involved in the process. They would have to then come in and request a transcript of judgment and have that judgment actually filed in the clerk's office of the county.
Julie, is it fair to say, and as to the Colony Justice Court, and presumably all town justice courts throughout the state of New York, that the forms are not provided by the court to potential litigants, nor are they filled out by any court personnel? Is that the way
That's
you
absolutely
see it?
correct, yes. They are responsible for obtaining the paperwork and filling them out. Again, we can advise them of the procedure, but we can't help them to fill in the blanks, so to speak. That's definitely a burden on them. Once it is all signed, and again, signed by myself or an attorney and served, the following paperwork is also the responsibility of the landlord, whether it be a warrant that needs to be submitted or whether it is the judgment that we talked about earlier.
And have you ever encountered other publications, or do you ever refer potential litigants as to where to find more information about how they should consider proceeding before they start proceeding? Have you run into any types of publications that you've ever been able to tell people they could look at?
We do, actually. The New York State Bar Association has put out a pamphlet entitled Rights of Residential Owners and Tenants that can be helpful to whether explain the process a little more or just give a clearer understanding of what the whole process involves.
And I've always found the landlord-tenant jurisdiction of the town justice court to be very substantial. Whereas in certain civil cases, a town justice court may only entertain actions for money up to $3,000. In the landlord-tenant cases, though, there is no monetary limitation. Is that your understanding
There
as
is
well?
not, especially if you look at it from the perspective of commercial buildings and commercial rents. There can be some astronomical figures associated with that, and the court actually does have jurisdiction as long as it's located in the town.
And as a result, I know that we've entertained and presided over matters involving commercial properties where hundreds of thousands of dollars are at stake in connection with the petition. And the trials can be very drawn out and involved, and as a result, it's a sheer indication of the type of the volume and the magnitude of the type of landlord-tenant relationships that we have in the town of Colonnade. As a result of that, though, we find that, in speaking of our $3,000 limit that we have, the court does enjoy other civil jurisdiction besides landlord-tenant. Isn't that correct?
It does, actually.
And what else can the court handle in the civil side of things?
Typically, on a routine basis, we are involved in several matters regarding small claims. Monies owed to individuals, and again, there is a limitation on the small claims of $3,000. But typically, we see a good number of small claims cases throughout the year.
And the $3,000 limitation in town justice court on small claims matters is the same monetary limit for our general civil jurisdiction as well, for people who are suing somebody for money damages only. Even outside of the small claims format, the court is still limited to $3,000.
That's correct.
Which does cause some litigants to have to go to other courts with higher jurisdiction as a result. Now, when people come to your office inquiring about commencing a small claims case, what is the procedure of your office?
Well, in this case, we actually provide the paperwork for that. Everything is obtained through our office, and generally, if someone is unfamiliar with the process, they're given a small claims booklet that's put out by the Office of the Office of the Unified Court System. It outlines pretty much everything that an individual would need to know about the small claims process, including the jurisdictional issue, which is where the person that they're suing either lives or resides. A lot of confusion arises whether the transaction occurred within the town or whether there was something occurring, some event occurring within the town where that is not actually the case in small claims. We're looking to where the person that you're suing actually resides or has a place of business or employment.
And jurisdiction is such a key issue, I have found, in presiding over small claims cases. First of all, isn't it true that in town justice court, corporations cannot use the small claims format to sue either another corporation or an individual?
That's right. Because we're a court of the limited jurisdictions, it's individuals suing on behalf of themselves or an individual acting as a DBA. Corporations, partnerships, and different entities such as that are not allowed to sue within our jurisdiction.
But can an individual sue a corporation in small claims court?
Yes, not to be confused with that, yes. If you're looking to sue one of those entities, that's absolutely fine, but one of those bigger businesses, corporations, or partnerships can't initiate the suit.
And I have found in presiding over a number of small claims matters that jurisdiction is provided wherein an individual who is seeking a claim against a national firm who has a local office in Colonie is allowed to gain jurisdiction over that national firm because they maintain an office to transact business in Colonie.
That's correct.
And we see those too, which has provided a lot of activity in that regard too. And often we've also found that many times a small claims trial can take a number of hours. And are there any pointers that you can give to potential litigants as to what they would need to bring with them in their effort to successfully prosecute a small claims matter? What should they have with them?
Typically what we try to explain to an individual filing is that they need to bring anything and everything needed to prove their side of the claim, whether it be witnesses, whether it be documentations, whether they need to obtain estimates and have estimates brought. And again, it's all outlined in our small claims booklet that we give out at the time of the filing. But they should be ready to go with anything and everything needed for their side of the case.
Exactly. And I think that, and all of our viewers should understand that the booklet is prepared by the state of New York, and we provide a copy of it to every litigant who comes and commences an action. And the document itself is rather self-explanatory, but it does urge potential litigants to make sure that you bring in estimates and credible estimates, and to be able to establish your claim for money damages. Don't you find that sometimes people want to start an action in small claims court seeking compensation for maybe emotional duress, and only come to find out that small claims jurisdiction does not allow
Routinely.
the court to provide that type of reimbursement in that matter? And the other thing that I've seen is that oftentimes litigants may come and not have the financial data to support their claim. And as a result, they may not be as successful as they had hoped. And I know that we always encourage people to attempt to settle their matter short of the courthouse because of the time and effort that's involved in a court proceeding, and sometimes it can be a day-long proposition, even for small claims.
Not only that, but I'd also like to just mention that the end result of a small claims is not the court enforcing someone to do something or return something. Again, it's strictly for that monetary value associated with whatever the claim is. You know, so ordering that bike be returned might not necessarily be what's going to happen, but if there's a dollar figure associated with something like that, that's where the court can become involved in that.
Now, you've been the Colony chief clerk here in one of the busiest justice courts in the state of New York for about 8 years, is that correct?
That's correct.
Have you seen an increase in the volume of civil cases over that time, including landlord, tenant, and small claims cases?
We have. I think just the growing number of businesses within the town, the growing population, and again, you know, the growing housing trend, we have definitely seen an increase on all levels of cases brought before the court.
Well, there's no question by taking a look at the dockets. Now, the court meets no less than 4 times a week. When are the court sessions in place in Colonnade?
Court sessions are Monday and Wednesday evenings and on Tuesday and Thursdays. So 4 out of our 5-day week are court sessions.
And is it fair to say that most of the civil matters are reviewed and enjoy judicial review on Thursdays of
That's
every
correct.
week? What about the other court dates? What are they for?
Well, Monday evening we hear our vehicle and traffic courts, so that handles all of our traffic tickets that are issued and any alcohol-related matters. And again, we reserve that for our jury trials. Every week, with the exception of some holiday weeks and different weeks, we have jury trials scheduled. So jurors are summoned to court and required to appear for the trial that's going to take place that night. Wednesday is reserved for our criminal calendar. As you know, we have defendants and inmates brought over from the Albany County Jail on a daily basis for arraignment and different purposes, and their cases are all going to be heard at one point or another on a Wednesday evening. And again, non-jury trials are held on Wednesdays, so there's quite a variety of cases throughout the week that are heard.
And what will go on Tuesday?
Tuesdays are reserved for our vehicle and traffic trial. In the event that an individual would like to plead not guilty and requests that a trial take place, we summons the officer to appear in court as well as the defendants. And at that point, it's their opportunity to have an actual trial conducted before the judge to determine the guilt or innocence of the ticket at hand. And again, some of our judges choose to do additional small claims on Tuesdays, depending on the volume of cases filed for that particular week.
Now, those civil proceedings, if they go to trial, there's a court reporter present, isn't that correct?
That's correct.
And as a result, a full record of the trial or hearing is made and, of course, made available to any litigants who would want one.
I would just add that it is at the cost of the litigant. If they choose to obtain a transcript of the stenographer's records, it is at their cost that they would make arrangements to purchase that.
And in fact, if someone wishes to appeal a decision of the court in a small claims matter or a vehicle and traffic violation matter, they would have to obtain that transcript and submit it to county court in a timely fashion in support of their appeal. Is that correct?
That's right. That's part of the requirement for the appeal, in addition to the initial filing of the notice of appeal and the fees associated with it. Part of that is obtaining the transcript so that the county court judge who is reviewing that case has a better understanding of exactly what transpired.
What type of pitfalls do you see for litigants who, and maybe unrepresented litigants that come to the office in seeking to commence either a small claims action or a landlord-tenant action? Are there any common pitfalls or mistakes that seem to be made that maybe we can help the citizens now, give them an idea of what to watch out for as they move forward, if they intend to move forward?
Absolutely. With the landlord-tenant issue, there's definitely legal restrictions as far as service, what type of service is acceptable, in addition to time restraints of filing and different things like that. It's not an easy process. That's not to say it's certainly not easy to accomplish on your own, but there are certain things to watch out for, making sure that the legal requirements are met for both filing and service, and just in general. The filling out of the forms, typically there's a lot of questions associated with that, whether it be because of the legal terms that are involved in the form, or whatever the case may be. We do see a lot of questions coming our way as far as the filling out and filing of the forms for that. Small claims, the biggest obstacle that we see is typically people may appear and not be as prepared as they should be, whether they don't have their witnesses, whether they don't have the documentation, as we talked about earlier, or just in general not quite ready to proceed at that time. That creates an obstacle for the court because it means subsequent dates and may create a calendar log, so to speak. So being as prepared as possible and just taking the time to read through the manuals and the literature that's available. I should note too that the small claims booklet that we talked about earlier is available on our website. It can be downloaded and read right off of that. Typically it's given right at the filing to the claimant who's bringing the claim, but if a defendant is served and would like to have the opportunity to read that, certainly they can request it from our office. But it's also available online for them to study up on and be prepared for.
Well, that's very informative. I know that it's very important to be prepared if you intend to come into the courthouse nonetheless. Now, is there a filing fee required by the state of New York for your office to collect in connection with commencing a small claims action?
Small claims is different than the civil filing fee. Small claims is based on the monetary amount that's being sought. So depending on the amount of the claim that's being brought would determine the filing fee. To be specific, if it's under $1,000, the claim is a $10 filing fee. And if it's $1,001 to the $3,000 limit, then it would be a $15 filing fee.
Okay. And I find, too, that the law does allow, the law that governs small claims matters, does allow the court to award a successful litigant the filing fee as part of a judgment.
That's correct.
And so that's available, and that can happen from time to time, too. Often, as we can imagine, the cases aren't necessarily so straightforward where that the court can come to a conclusion that only that one person has won their case entirely. And in fact, routinely, what we will find is that there'll be a counterclaim filed. And as a result, there are two claims being considered at the same time, and the court has to consider both at
Yes.
the same time. And oftentimes, there isn't necessarily the relief that's provided by the court under the law isn't necessarily what the litigant was hoping for when they started, nonetheless. But that's what it is in the court system. And we're very lucky to have you, Julie Gansle, keeping an eye out day in and day out on the Colony Justice Court, which is really a flagship justice court here in the state of New York, and it's no doubt due to your control over the court and your dynamic staff that serves all of us and the citizens of the town of Colony so very well.
Thank you.
And we certainly look forward to having you back. I hope you'll join me again for Benchmark as we continue to provide information to the town residents about issues that involve the court system and the legal system.
I would love to.
So thank you, Julie, very much for being with us today. I'm Town Judge Peter Crummey, and thank you very much for joining me on Benchmark. I hope you'll join me again as we continue to explore issues involving our town residents, our town court, and our legal system. Good day.
Welcome to Channel 17, the Town of Colony Government Channel.